The Supreme Court of India on Thursday ruled that a high-power committee will be formed constituting the Prime Minister, the Leader of the Opposition in the Lok Sabha and the Chief Justice of India to appoint the Chief Election Commissioner and the Election Commissioners. The Election Commissioner of India and the Election Commissioners till date were appointed by the ruling party at the centre. For the last 73 years plus, this has been the norm, ladies and gentlemen. However, the Supreme Court's decision has taken away the solo decision, making the right and West the right to appoint the Prime Minister and the Leader of Opposition in the Lok Sabha and, of course, the Chief Justice of India till the Parliament passes a law. The Constitution does not lay down a specific legislative process for the appointment of the CEC and the ECs. The President makes the appointment upon the advice of the Union Council of Ministers headed by the Prime Minister. The decision by the Apex Court comes amid allegations that the Election Commission seemed to function with prejudice for the ruling party at the centre, considering they were the one who brought the Commissioner to power. Earlier, while hearing the bunch of petitions, during the course of the hearing, the central government came into the Supreme Court's firing line for neither framing a law that defines the process of appointment of the election commissioners, nor laying down the eligibility criteria for their appointment. The top court spoke out on the need to insulate the Chief Election Commissioner's office against political pressures. Now, during the course of the hearing on the matter, the government, arguing its position, had pushed back strongly against the court's inclination to devise any mechanism to appoint ECs and CEC. It called the court's suggestion to seek judiciary's help as fallacious and constitutionally impermissible. This is all during the course of the hearing. Let's go straight across to Abhishek Manu Singhvi ji, joining us, senior advocate, MP Rajya Sabha, member of the Congress party, also with us. Namaste, Jai Hind, good to have you with us, Abhishek Manu Singhvi ji, after a long time.
Namaskar, yes.
Your thoughts on the Supreme Court's judgment. Let's start from there. Where do you stand?
Anand, the right stand, on your right stand would be for all right-thinking persons to support, and I'm trying to be as non-political, apolitical as possible. Of course, you are bound to draw inferences because of the fact that I'm associated with the Congress. I believe it's a historic, indeed a momentous decision, not only because it has provided a bulwark, a foundation for independence, but because it has walked the talk. A lot of Supreme Court judgments may give a lot of sermons, a lot of didactic passages, but they don't walk the talk. Here there is a walking of the talk. And if you'll give me a couple of minutes more, Anand, let me tell you that, as you rightly said, this was strongly opposed by the government of the day. I understand that this has been the situation for the last 75 years, but there is a provision in Article 324 which says that Parliament by law, and therefore the court, the Apex Court, is entitled to legislate in the interstices by providing for this mechanism till such law as Parliament may ordain is enacted. That's the broad legal framework. So there's nothing legally infirm because there is a gap. Parliament has not enacted law, and the court is very careful in making this framework within the confines till such time as Parliament enacts the law. However, politically, I believe that, first of all, I believe genuinely that no government should support the making of a law reversing this framework. Second, I think it will be very difficult to find a consensus, even remotely, of passing a law which will change the basis of this judgment.
Right.
The reason is, yes, all governments have been complicit to some extent in not doing this law earlier, but I have no hesitation in saying, and I think if right-thinking people put their hand to their heart and speak objectively, there has been clearly a greater assault on institutions since the last 7-8 years. There has been a greater approach of control freak approach. There has been a greater approach of somehow directly, indirectly or otherwise being able to dictate to or control institutions. And therefore it is timely, it is apposite, and it must be supported and it must be opposed if laws are intended to be passed to reverse this. One last sentence, Anand. There is therefore imperative need that the one exception in today's polity, which is not governed by this. The Lokpal is governed by a similar framework. The NHRC is governed by a similar framework. The CBI has a similar framework, etc., etc. This is important that the ED is subjected to a similar framework. Regrettably, the government of India has passed a law in the reverse direction. not only extending by executive order the term of the ED head, but passing a very strange law saying we can extend it further for 5 years, but no more than 1 year at a time. A piecemeal extension is the antithesis of independence. It is intended to keep the person hanging and dependent upon you. It is intended for him to look upon you as the puppet master who will control the puppet. And that part should also, of course, it is not so in this judgment. I am proposing that it should also be subjected to a similar regime.
Jay, there are various aspects which I'd like to like your thoughts on. One is that why is it that the Parliament has deterred on forming a particular law on the construct and appointment, nature and appointment of the eligibility and appointment of the Chief Election Commissioner so far? So is it easy, or is it just getting away by broad brushing 73 years of inaction and blaming it all on the current disposition?
No, I did not. I am not starting by blaming the current disposition as far as non-enactment of law is concerned. I am blaming squarely the current disposition in increasing the gravity, the degree, the nature of the insidious intrusions on all institutions, including the EC. And let me make it good since we are talking only of EC. In 2019, Anand, and the electoral verdict was completely in favor of the BJP. No problem. I'm not on that.
Jay.
I'm giving your answer as to how I am, to what extent I am blaming it.
Jay.
The government of I was in fact in charge of that, and almost 25 or 24 complaints went to the EC in the heat and the dust of the 2019 elections. The EC broadly decided some 15, 17 of them, which were serious but not at the very top.
Right.
And they either gave an order of restraint or they dismissed the complaint, but they did something. Because as you know, the election window is 6 to 8 weeks only. Unless you act promptly, you will get the fruits of your infraction.
Yeah.
But in the 5 or 6 cases which involved the Honorable Prime Minister and the Honorable Home Minister, the EC did a very strange thing. They decided not to decide either way. There was no decision. And as those 1 week became 2 and 2 became 3 and 3 became 4 and 4 became 6 weeks, we had to go to the Supreme Court saying that now it is virtually infructuous. The window of election punishment during the Model Code of Conduct is getting over.
Right.
So the Supreme Court in the last few dying days of the election, before the polling, said, you better take a decision immediately.
Got it.
A decision came in favor of these two persons. There was a dissent, well known in the public domain. The dissent was not even allowed to be published. We applied in RTI and elsewhere to get the dissent. They said it's not our practice to give you a dissent. The person who, according to the government, perhaps had the temerity and the audacity to dissent, according to me, had the independence to dissent, was hounded and lampooned in the press subsequently for many weeks and ultimately left his post. Now, this is only an easy example. I'm not giving you other examples of other
We'll keep it in this domain. I just want to move on because there are other aspects too. The fact is that this has been blamed by whoever has been in the opposition against the government, whoever has been in power, of wanting to exercise absolute control. It's on record that the very same top court has called institutions like the CBI a caged parrot under other political dispositions. My question, Abhishek Manu Singhvi ji, is that in this case, it's a constitutional appointment. Should it not have remained in the realm of the executive? The moment the one of the third members is the Chief Justice of India or the CJI, the judiciary's interference, that's where many people are saying this is judicial overreach. The other aspect they are saying is that you are giving the CJI veto powers, because if the government and the LOP don't agree, the CJI then holds veto power. How is that fair?
I think that's the precise object. Each should have a veto power to an extent. And let me tell you that now you're asking a sanitized legal question, so it deserves a proper legal answer. If you say judicial overreach, the court has been very clear, very careful to steer clear of that charge. There is, if I had made a law saying Anand can be appointed only by 1, 2, 3, that might have been called a direct judicial legislation. The court has very carefully crafted by first pointing out Article 324, which says Parliament may by law. Then they've said, because Parliament has not stepped in by law, we are stepping in to fill the gap till such time as Parliament passes the law. Now, if you have the guts, if you have the consensus, if you have a all-party consensus in this, change the law.
Okay.
This judgment will stop.
Or draft a law, because there's no law at all. There's no law at all. Yeah. Sorry. There's no law in the first place. So you have to first draft a law. There's no changing of the law.
Draft the law. You have to pass the law with a consensus, including in both houses. This is not a money bill. And I mean, I personally believe that there will be no consensus on this, but of course, a brute majority can ram it through. But I'm answering your other question, that the court has done naked judicial legislation. It has usurped legislative power. That is not right, because the juristic basis of this is Article 324(2), which people don't read, which empowers Parliament, and till such time as Parliament has come, the judiciary has utilized this gap.
But the fact is that if tomorrow, till the time a law is passed, there is a chief election commissioner appointed where the vote of the CJI or with the confidence of the CJI, and then there are complaints against that CEC, then will the court take action against somebody who's got the thumbs up or the approval of a former Chief Justice? That's one question.
Absolutely.
Or will there be a hesitance there? Secondly, if the judiciary, sir, my second part to it, and this is my final question, so you can answer both in either part. This is the first part. The second part is that if the judiciary itself is blamed of being opaque, not opening and not being transparent, then can it impose transparency on other bodies, be it the executive or the legislature?
See, you are of course expanding the debate, and you are rightly being the devil's advocate, perhaps departing from the right stand. But let me answer both the questions. The answer to your first question is yes, yes, and yes. The Chief Justice of India as a part of a selection process is absolutely nothing new. The Chief Justice of India sits on several other selection processes, including, if I recollect, Lokpal and NHRC. Secondly, the fact that I, in a panel of the Chief Justice of India, select you does not create any estoppel of any kind. If you do an infraction and then that infraction goes to court, there is no question of the fact that because you have the imprimatur of selection by the Chief Justice, the only effect it has is that the Chief Justice will not sit in on a bench which decides a judicial challenge either by you or against you.
The CJI will recuse himself or herself.
Thirdly, yes, the judiciary has lots and lots of problems. I am one of the fiercest critics of some of those problems, while being a very great admirer and supporter of the judiciary. And in that sense, I am an insider, outsider on all three organs. But the problem of the judiciary is not the issue we're discussing now. Let's have a panel discussion. Let's have a discussion with you on the arrears, which is a major nightmare for the judiciary. Let's have a problem on the lack of a process for integrity decision. I'm prepared to speak on that. But the fact that that is there is no ground for criticizing this judgment. And let me end by saying one thing, Anand. It's an irony. Basic structure includes free and fair elections, democracy. The mega policeman for free and fair elections and democracy itself is therefore the EC. It is ironical that other bodies have a similar system which has now been put by this judgment, but the EC never had. So I would only pray that I hope and trust to God that the legislation, A, if it happens by the government, is not to the opposite direction, as was the case with ED. B, it will not be passed.
Well, we have to wait and see what happens if there is a law that is drafted and if that is brought over and if the legislature actually brings in a law which has not been there in effect in 75 years. But whatever happens, it's in continuum. So tomorrow, if governments change, parties who are in opposition come into power, they will still have to go through the same process as now spelt out by the courts, or what is then passed in Parliament as a law if a law is quickly enacted. Abhishek Manu Singhvi, thank you. Always a pleasure speaking with you. And yes, I will take you up on the aspect of judicial reforms, transparency of the judiciary itself, and accountability of the judiciary. On that, I will seek your time and we will speak at length very soon. Thank you very much.
Thank you.
Thank you.